number 55 on the calendar, Sassi versus Mobile Life. Counsel?
Thank you, Your Honor. May it please the court. My name is Jonathan Goldman from the Law Office of Sussman and Associates. On behalf of the appellant Richard Sassi, I'd like to reserve 1 minute of time, please, if I may.
Of course you may.
Thank you. Dismissal of the complaint here was erroneous and should be reversed because the complaint amply sets forth a prima facie violation of Article 23A of the Correction Law and Section 296 of the New York State Human Rights Law. Specifically, the complaint pleads that 1, plaintiff was an applicant seeking employment with a private employer where he did not then work. Second, he had a criminal conviction that predated that application. And third, he was denied employment because of that prior criminal conviction.
Counsel, can I ask you something? So let's say different facts, not your case, different facts. Someone is convicted while they're working for the employer. They do 5 years in prison, and they come out and they say, I'd like you to hire me now. And the employer says no. Is that enough?
I'm sorry, is that
enough? Do you have a claim?
I believe you do, Your Honor.
I mean, assuming they didn't go through the factors and all.
That's correct, Your Honor, exactly, because again...
What if they filled your job in those 5 years?
Well, again, so going to Your Honor's prior hypothetical, I would assume that there was a position open to apply to, so I agree.
Isn't that the assumption you're also asking us to make here based on your complaint? Because as I read it, in a fair, and I understand our rules for generous reading of a complaint, read it, I think it's close at best to say, it really reads to me as almost, okay, suspension or, arguing over whether I can come back, but nowhere in here does it say there's an opening that I applied for. And I think without that, then isn't it the case where 5 years later and I filled the job and I come back, the person comes back and says, hey, I really want my job back. Don't you have to allege that there is an opening?
I agree there needs to be an opening, but I would submit, Your Honor, that the complaint liberally read amply satisfies that, at least the inference of that. He was gone for a few weeks on his 60-day sentence. He came back, as alleged in the complaint. There were discussions. Some people did want him to come back.
But it says regain his job, return to work, reassume the work. It says reemploy.
It does say reemploy, Your Honor. It says regain, reemploy. It doesn't say, we don't allege that the respondent unlawfully terminated him. We allege that the respondent unlawfully denied his application for employment. And again, the complaint does not say that he was denied because there wasn't a position. It says he was denied because of the conviction.
Well, you certainly wouldn't allege he was denied because there wasn't a position, but do you have to allege that there was a position open? I think that's the question I'm having.
Well, again, Your Honor, and that specific question, wasn't really dealt with in the briefs because it wasn't the basis upon which the court dismissed below. The court dismissed below because it said that the statute does not apply because it interpreted this as an unlawful termination claim. I think if you read the complaint in its totality, in the light most favorable to the plaintiff, it amply alleges at least the inference that there is an opening that he was seeking to fill, and it was denied solely because of the conviction, which therefore violates the statute.
I just want to clarify, and you can correct me if I'm wrong on my recollection of the complaint. I thought the complaint alleged facts, which we assume is true for purposes of motion, that he was told that he was not coming back and they would not hire him, not because of Judge Garcia's hypothetical, which is a very interesting and complex one, but because of his criminal record.
That's correct, Your Honor.
You have the factual basis that is asserting that the grounds are not a lack of a vacancy in an employment position.
That's correct, Your Honor. It's explicitly pled that the denial was not based on the lack of an opening, but because of the conviction, which I think you could reasonably infer there was an opening to deny because of whatever reason.
But in response to Judge Garcia, you're conceding that if indeed there was no opening, that he would have no claim? I just want to be clear on your argument.
Again, that wasn't an issue that we've addressed, but I think as I'm hearing it now from Your Honor, I think we'd have to concede that if you're applying for a job, you have to be applying for something that is there. You're not automatically entitled to something if it doesn't exist. The statute protects against people applying for employment.
Yeah, let me ask you this. When he first applied, and then he gets hired, when he first applied, was he applying for a targeted position, or was he applying to work for the company and then they put him in a particular position that they thought was appropriate?
I don't know the specific answer except to say, as pled in the complaint, he applied and was applied for the position, was hired into the position of that's alleged in the complaint, and then was promoted to a dispatcher position, which is the position, by the way, I should also highlight, and I think this is one of the key important facts in the complaint, is that it specifically alleges at paragraph 26, he was terminated for job abandonment. At that time, he was separated. He no longer worked there. He comes back weeks later after he finishes serving his term. He asks to be employed again, which we submit respectfully under the plain language, unambiguous language of the statute. Any application by any person for employment, his request to be employed, whether it's to his position that he left or any other position.
Let me ask you this. How far does the liberal interpretation of the complaint go? Let's say you characterize it as you do, but the only way to actually understand the complaint is an unlawful termination. Can we do that, or does our law foreclose that?
I'm sorry, I don't understand. You're saying is the only way to interpret...
Whatever you may be calling it, whatever you may assert, if the only reading one can have of the complaint is that, in essence, this always boils down to challenging the termination, not an actual reapplication, even if you called it that. Does our jurisprudence allow for us to say, doesn't matter the label you put on it, this is only about an unlawful termination?
I think I understand Your Honor's question. I would respond that I think your jurisprudence requires you to look at all of the facts alleged in the complaint in their entirety and take the most favorable and liberal reading. Now, if the most favorable and liberal reading and the most reasonable and only reasonable reading leads you to that determination, well, that's something else. But respectfully, again, we submit that does not lead to that conclusion here. The complaint, when read in its entirety, liberally says specifically, not just a conclusory label that it was a termination, the specific underlying facts. He was separated, terminated for job abandonment. Then he comes out and he asks for employment. At the time he asked for employment, he was not employed. The conviction predated that application, and he was seeking employment. Under the plain and unambiguous language of the statute, then, it applies.
So let me ask a logic problem that would grow out of that. One of the things that I struggle with on this is, so you're fired or you're let go because of job abandonment, and or let's say a conviction for a crime here, and that occurred during employment. You do your time, you come back out. Would anyone have to be rehired because they put in a new application? Because under the you're reading of the statute, the conviction would precede the new application for employment. Is that what you're arguing?
Well, again, just to be clear, it's not a guarantee that you're going to be employed. It's just a guarantee that your conviction will not be used against you unless one of the exceptions applies. And that would be my position here.
Can I ask us just a procedural question? Was this decision made on a pre-answer motion to dismiss?
Yes, it was, Your Honor.
Thank you.
Yes, it was.
Can I just follow up on Judge Fahey? So if someone is terminated because of a conviction, let's say at 3 o'clock, right? And you're alleging that that's okay, right? An employer can terminate someone because of a conviction.
Yes, Your Honor.
At 3:05, they say, I am reapplying for this job. If we adopt your approach, doesn't that just negate the legislative intent here?
I don't believe it does, and here's why, Your Honor, for a couple reasons. First, again, I point to this plain, unambiguous text that says any, and that would fall under any. And I concede that's an extreme example. Second, the policy of the law is very clear, and it's a liberal statute, a broad remedial statute that should be liberally interpreted to satisfy its goals. I see my time's up. May I finish the answer?
Please do.
Thank you, Your Honor. Here again, employment is not guaranteed. A conviction that occurs during someone's employment oftentimes involves contemporaneous conduct, usually conduct that occurs on the job. There's practical considerations. The person might be incarcerated and therefore not available. Oftentimes in those situations, the employer will undoubtedly be able to satisfy the Article 23A factors to find an exception and deny employment, even in Your Honor's hypothetical. But that's not the case here. The conduct was years prior, had nothing to do with his employment. And if we look at the Bonacorsa case where somebody applied 8 years later for a license that they had held 8 years earlier, there was no question that the statute applied. And that's the only question here, does the statute apply? So if it applies 8 years later without any other legislative guidance as to how long is enough, I don't think it's appropriate to say, well, 5 minutes isn't enough or 6 months isn't enough. Who's to say? Any means any. So here in your example, I would submit that it would apply. Again, it's not a guarantee of employment. It's only a guarantee that the factors would be applied and a conviction could only be held against you if an exception applies.
Counsel, I have a final question for you. Given the timing of the events in this case, why aren't the termination and those post-conviction discussions that Mr. Sassi had with the company, why aren't those part of the same employment determination?
Well, they're not part of the same employment determination because, as a matter of fact, they were separate instances. So, and again, as the complaint sets forth, they actually had told him, we're going to allow you to burn your accrued time. We'll put you on leave and you'll just come back. But and again, as the complaint says, they didn't do that. Once he didn't come back to work after a few days because he was in jail, they terminated him. They completely separated him from employment. Then a period of time went by, more than just 5 minutes or a half hour, several weeks in fact, and he went back and said, you weren't supposed to terminate me in the first place, but that's besides the point. I would like employment with your agency, with your organization, and they denied that. So just as a matter of fact, they're separate events that happened spatially and temporally attenuated.
Thank you, Counsel. Counsel?
Thank you, Your Honor.
Welcome.
Thank you, Your Honors. My name is Matthew Cohen. I'm an attorney from Coffin, Dulwich, and Volokh. We represent the respondent in this matter. The Second Department correctly affirmed the decision and order of Judge Brands, which correctly noted that in the verified complaint, plaintiff alleges that he was first employed by defendant, after which he was convicted of a crime and incarcerated for 60 days, after which plaintiff sought to resume his employment with defendant. The key word being resumed. There was no reapplication here, and even a most liberal reading of the complaint, I don't see how you could view this as a new application.
Are you arguing now that plaintiff was never terminated?
No, he was terminated, but if you take...
So when was he terminated?
He was terminated while he was in jail.
What date?
It was during the 60-day period when he was in jail.
You can't be more specific.
I don't have the exact...
Okay, that's fine.
I don't have the exact date.
Okay, thank you.
So when he approached his employer to discuss coming back, irrespective of what was in the plaintiff's mind, he was actually asking for employment. He was asking for re-employment, I guess. He wanted his old job back.
I believe it's as Judge Brand said, it's a resumption of employment. And in fact, if in the...
But you said he was terminated. If you're terminated, I'm not sure, maybe it's just a semantic issue.
Correct, because the plaintiff was in jail. He was in jail for 60 days. When he came out of jail, he's contacting his employer to see what was going on. The conversation that is listed in the complaint after that, the Director of Human Resources, and this is just based on the allegation, told plaintiff, as the company had previously terminated others who had been incarcerated, they had to be consistent and terminate plaintiff. They're talking about the termination that already took place.
Let me ask you a couple of things. One of them about what you just quoted. One is that reason sounds to me exactly what the legislature is trying to get to. It has nothing to do with the merits or the qualifications of the individual, whether or not he's doing a good job or not. And it's not even about his conviction specifically. It's sort of anybody who's convicted, they're terminated, they're out. And it does sound like that is against the public policy that the legislature sought to put in place through the legislation. What's your response to that?
Respectfully, I disagree with that,
ahead.
Your Honor.
Go ahead.
The statute very clearly says it applies to prior convictions. This clearly was convicted while he was while he was employed. If you had a
So
situation
on that
where...
point, that's why it matters if it's a job abandonment, and he was terminated for that reason, or he was terminated because he was one of among many employees who were terminated because they had had a conviction. You see why it makes a difference? There's a difference there between the two things.
Yes, Your Honor.
All right, so that being the case, that's a question of fact, isn't it?
Correct, Your Honor, but...
All right, so if it's a question of fact, then wasn't a pre-answer motion to dismiss an instance that was granted? I can't blame anybody for arguing it, but the granting of it, wasn't that really premature adjudication? Should have waited till that fact was clarified.
I disagree, Your Honor. I feel that the statute would be rendered futile if you could go to jail
Your
for 60 days...
argument is because, let me just ask, it's because of the previous conviction argument.
Correct, because he was employed when he was convicted. If you could be terminated while you're in jail, you come out, you have your initial conversation with your employer who just terminated you because you were convicted currently while you're employed, there would be no use of having that word previously convicted, prior conviction. They would render that term obsolete. And that clearly was the legislative intent, that it only applies to prior convictions.
If I'm now understanding perhaps more clearly
Yeah.
what you're arguing, you're first arguing this is a wrongful termination. There was no reapplication or another application. That's your first line.
Correct.
But as I understand what you're saying now, you're saying even if it was, the statute does not protect him. Am I understanding you
Correct, Your Honor.
correctly?
Yes.
Because even if it's a reapplication, because the conviction doesn't predate the original application, perhaps you're thinking along the same line of the questioning from the Chief Judge. It's all part of sort of one event cycle.
Exactly. I think this is analogous to the example that the judge gave earlier, where what if at 3:05 somebody came by and, oh, you just fired me 5 minutes ago, I'm going to reapply. It's really the same thing here. The person was
Well, but
fired, the plaintiff was fired while in jail.
Let me ask you about Judge Singus's example, though.
Yeah.
So, as I understand it, if you're fired at 3:05 and you go back to the employer who immediately fired you, 5 minutes later, you've already been terminated, and say, I would like to file an application for a job.
Yeah.
The employer can say no, and the statute doesn't protect the employee, but if that employee at 3:10 comes to me and asks for a job, I can't use the prior conviction. That's your interpretation of the statute?
Yeah, if you're a different employer, yes.
So where in the statute do you see that the statute reads differently on the employer who fired you and any other employer?
I'm not saying it goes on forever, for infinity. It goes on just logically. If somebody is terminating an employee, if you have a right to terminate an employee for a conviction that occurs during your employment, you have to have an ability to terminate them. If somebody could just come 5 minutes later and reapply for that same job, and you can no longer terminate them, it renders the statute obsolete.
What if they came and reapplied for another job?
For
The
another
same type of job, but the one that someone left while they were incarcerated. How about that? Can they do that? Same skill set, same title, but it's not the exact same one that they had.
If it was a legitimate reapplication?
No, they're applying for a different job.
Yeah,
With the same employer.
If you're applying for a different job, yes, but that's not what was alleged in the complaint here.
You don't think that leads to absurd results?
I think
So
it could lead
Judge Wilson's question to you, this question, you don't think any of these are absurd results, or perhaps, even if you don't think they're absurd, they seem to not be in line with the legislative intent?
I disagree with that. Right now, in the state legislature, there was a bill, I think brought out in April, it's in committee now, where they're trying to remove the prior conviction part of the statute. There would be no need to do it if 5 minutes later I could just reapply for the job. So to me, the legislative intent was that if somebody's convicted during your employment, you can terminate them, and that's what took place here. They terminated him while he was in jail. He came out after was talking about it.
Would it be fair to say that the legislature was probably imagining that most people who are incarcerated spend more than 5 minutes in jail?
Probably.
Okay.
Yeah, but still here, again, this was a short period. It was 60 days in jail. He came and spoke to them, and a reading of the complaint. It is not a reapplication. I'll even point out, even though this really isn't part of the record, in the initial briefing papers, the very first line of the opposition from plaintiff referred to it as a suspension. There's nowhere in the complaint that it's an application. He got out of jail and he's
But
having a
again, aren't you
conversation.
then sort of having the challenge of addressing what I believe was Judge Fahey's line of questioning? That's his factual assertion.
No.
Your company has a different view of these conversations and what occurred. It's a factual dispute. You can't resolve this on this motion. That's why I asked you about your second line of argumentation, which I
Yeah.
understood to be as a question of law, not as a question of fact,
Yeah.
which would then mean regardless of the facts. Take it as he argues it. It doesn't matter because the statute doesn't apply.
Correct. I agree it does. Like I said, if what plaintiff is looking to apply the statute in the way plaintiff wants to do it here, the prior conviction language would be rendered obsolete. Nobody would be able to terminate an employee who's convicted during their employment for the simple reason being 2 minutes later they could walk back and reapply.
So if it didn't have that word, or whatever way the phrase is found
Yeah.
in the statute, do you concede then that he would be right?
If it didn't have that word, yeah, but that's an important word.
Thank you, counsel.
Thank you.
Counsel, you have 1 minute of rebuttal time.
Thank you, Your Honor.
You're welcome.
Just very briefly, to answer the question about the date, it's not specifically in the record, but if you would like the specific date, I do have it for Your Honor.
Counsel, on that point, just to clarify something, I think it was Judge Fahey, though, who was asking about, and I want to understand if I have your argument right. If somebody, hypothetical, gets convicted, assaulting a child, let's say, and they get 1 month and you terminate them for job abandonment, your position would be that, just that part is okay under the statute.
Yes, Your Honor.
Now, that same person gets convicted of that same crime, and for whatever reason, they get no jail time. You can terminate them or not terminate them based on the conviction alone without the job abandonment part.
Well, you could terminate them for any reason, and again,
So it's not the question of fact whether it's abandonment or just the conviction.
Well, a couple points. I think the fact that they fired him for job abandonment is relevant to the extent that when he comes back and reapplies and now they're calling it a conviction.
I understand that argument,
Right.
but just in terms of would it be a violation of the statute, it doesn't matter if it's abandonment or just based on the conviction.
Well, again, if they're saying abandonment as pretext for the conviction, then it might make a difference. But if it was actually
No,
for
but let's say
abandonment.
they just say conviction. I'm terminating you because you were convicted. Is that a violation of the statute?
No, it's not, Your
Okay.
Honor. It's not.
So
Your
it's
Honor.
not a question of fact, their reason, whether it's abandonment or the conviction alone. The termination part.
Right, exactly. The reason for the prior determination is not necessarily a relevant
Okay.
factual dispute here. The factual question that's relevant is whether the complaint amply alleges that he was terminated before he made the application.
And what if the employer said, I realized during this time I only need 3 people for this job rather than 4?
I mean, that would raise a factual issue as to their motivations. And again, that's not what's alleged in this complaint. I agree. Like I said before, there might be some extreme examples. There might be significant factual issues that arise in these cases. But the legal question that's before the court and on which it went off below is whether the statute applies in these factual circumstances.
Thank you, counsel.
Thank you very much, Your Honors.